Very good evening, students. Very good evening, Akhilesh. Akhilesh, please confirm about the voice and the video. Okay, all clear? Chaliye, thank you very much. On that note, let's begin with this class. So, first of all, I welcome each one of you to my mock test on UP PCSJ. Let's start with my brief introduction first. In case if you don't know my name, it's Sandeep Khatri. These are my areas of specialization, as you can see on the screen: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so please do make sure that you follow that to get all the updates about my special classes and my plus courses. I have also shared the link of my Telegram channel where you can connect with me and ask questions in relation to your judicial preparation. At last, I have mentioned my code, that is Khatri10, which you can use to get a 10% of discount for all the plus courses, and also you can use the same code to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So today we are going to discuss some previous year questions only from UP PCSJ, and all the questions which we are going to discuss today are basically from your 2018, the last previous year question paper. Okay, ji. Very good evening, Kirti. Chaliye ji. On that note, let's begin with the test. First question: which of the following sections of the Indian Evidence Act deals with conclusive proof? Okay. Akhilesh and Kirti. Correct answer: 41, 112, and 113. All these three sections are basically example of conclusive proof. The term conclusive proof has been defined under section. Which section defined the term conclusive proof? Very good evening, Amit. Yes, students. Section number 4 defined the term conclusive proof. What is the major difference? What is the major difference between the concept of shall presume and conclusive proof? What is the major difference? Yes, please. Amit, it's not section 3, section 4. Section 3 is the interpretation clause. All the definitions has been given there. It's section 4 that define presumptions. Yes, who can tell me what is the major difference? What is the major difference between conclusive proof and shall presume? There is the two are both different presumptions. Now my question is, what is the major difference? Okay, Kirti, correct answer. Just an important key term is missing in your answer, and that is when it comes to conclusive proof, that is irrebuttable presumption. But when it comes to shall presume or may presume, that has rebuttable presumptions. Okay. Correct answer, Amit. Okay, perfect. Moving to the next question. Res geste is allowed as an exception to. Top 3 students to answer correctly: Satyam, Kirti, okay, Akhilesh and Amit. Please do correct your answer. So the question is indirectly, res geste is allowed as an exception to, which means hearsay evidence is no evidence. But when it comes to in res geste, that will be treated as an evidence. Okay. Now my counter question to each one of you: why res geste allowed hearsay evidence as an exception? What is the reason behind that? So it's basically a question from the mains and interview examination. Yes, please. In a general rule, hearsay evidence is no evidence. But why in res geste? It is considered as a valid evidence. Come on. I can expect a correct answer. I hope the question is clear to everyone. So if you have answered hearsay evidence, I'm just asking about the reasons. Why? Kirti, you have to explain that. Students, try to learn to use the important key terms to complete your answer. Like Kirti and Satyam, both of your answers are correct, but again, a key term is missing there. Like, okay, let me help you out here. If Kirti and Satyam, if you are writing it is because of the same transaction, then then my counter question again, then how the concept of same transaction is making hearsay evidence an evidence? Okay, you have given the case law as well. Completely correct answer, Amit. That the thing that was missing was spontaneous. There is no chance of planning and everything. Yes, the answer is correct, and that is students, because when it comes to res geste, everything happened in the transaction, in the same transaction. You don't have the time to plan things. You don't have the time to think about the things. Okay, so if there are reactions, that must be all those reactions that are quick, that falls under the same transaction, will be, even if that is hearsay evidence, will be considered as an evidence. Okay, correct answer. Moving to the next one. Palvinder Kaur versus State of Punjab relates to which of the following? All these are your previous year questions from 2018. First one to answer correctly, Ankit, followed by Satyam, Kirti, Amit, and okay. Everyone's answer is correct. That is B, confession. Okay, I have some associated question in relation to this concept. The first is the most basic one: whether the term confession has been defined under Indian Evidence Act. Yes, please. First one to answer correctly, Kirti, no. Amit, no. Satyam, no. Okay. Now the next question is कि when we talk about confession under Indian Evidence Act, there are sections from 24 to 30 that deals with the concept of confession. Now section 24 to 30 is judicial confession or extrajudicial confession. I'm repeating myself. Section 24 to section 30 of Indian Evidence Act deals with the concept of confession. Now that particular confession is judicial confession or extrajudicial confession. Okay, Satyam is saying both. Kirti is saying judicial. Okay, Kirti, you have answered both. Judicial and extra. Okay. Satyam, do you have any reasoning behind that? How the answer is both? Do you have any reasoning? Okay, let me help you out here. Let me tell you the meaning of what is judicial confession and what is extrajudicial confession, and then we will see if someone wants to change their answer. Right? You will not get these kind of facility in your real-time examination. Okay, but let's see if you can reach to the answer. Judicial confession means when the confession has taken place before the magistrate. Okay, that is your basically judicial confession. And if you are not giving confession in front of a judicial magistrate, other than the judicial magistrate, anyone, that person can be anyone other than the judicial magistrate, then that will fall under extrajudicial confession. Now you please answer. Section 24 to section 30 deals with judicial confession or extrajudicial confession. Okay. Okay. Now let me conclude. The answer is, students, when it comes to section 24 to section number 30, that is extrajudicial confession. Why extrajudicial confession? Because section 164 of CRPC is judicial confession. Okay, that deals with the process that how you can submit your confession there. Okay, so it is all about here when it comes to these sections, it is extrajudicial confession. Okay, I hope it's clear. Chaliye. Next one. The Criminal Law Amendment Act 2018 comes into force from. So before it was Criminal Law Amendment Act 2013. That was an important. That was from the important part. And now it's Criminal Law Amendment Act 2018. Amit A, Akhilesh A, Kirti don't know, Satyam C और B. एक ही आंसर नहीं आया जो करेक्ट था, that is D. So my students are bad in guessing as well. ठीक है जी? So it's 21st April 2018. Okay. Next. The doctrine of joint liability as envisaged by section 34 of Indian Penal Code 1860 is based on the decision of the following. Top 3 students to answer correctly. Satyam, followed by Kirti, Amit. Correct answer, students. That is Barendra Kumar Ghosh versus King Emperor. I hope you all are aware with the facts of this case. It's a landmark judgment and examiners one of the favorites topic. Can anyone tell me Mulche versus R? It's a landmark judgment on which topic of IPC? Anyone? Kirti, completely correct answer. Mulche versus R is a landmark judgment when it comes to the concept of criminal conspiracy. What about Pandurang versus State of Hyderabad? This is again a landmark judgment. It's a bit complicated as well, let me tell you. Pandurang is not easy to understand. It's a good case law. So Pandurang is again on section 34. ठीक है जी. Next. अखिलेश, आंसर टू योर क्वेश्चन 34 हाई कोर्ट के द्वारा दिया गया था. नो, इट वाज बेसिकली नॉट हाई कोर्ट के द्वारा, बट दैट case was one of the landmark judgment when it comes to section 34. Okay, the another one was Mehboob Shah versus King Emperor. Kirti, Amit, and Milky. Top 3 students to answer correctly, and that is C. Okay, that is C, which means when it comes to wrongful gain and wrongful loss, both are under section 23. Okay, when it comes to gang rape on women under 12 years of age, that is 376 dB, and when it comes to gang rape, that is 376D. Okay, so the incorrect one is Harbor. This is basically 52A. In which of the following cases the Supreme Court has remarked that husband is not master of his wife? Oh, sorry about that. Your name is Millie. Okay, sorry about that. My mistake. Question number 7. Top 3 students to answer correctly. Kirti, Akhilesh, Amit. Correct answer. That is basically landmark judgment on section 497, that is adultery, which is Joseph Shine versus Union of India. That husband is not the master of his wife, and in that case, that was section 497 was struck down, held unconstitutional. Now this one is interesting. Consider the following cases and arrange them in chronological order. Indirectly, these kind of questions, they are basically asking you about the year. So if you know the year when that particular judgment came, you can easily answer. Usually students ask whether we need to remember the year as well of from the citation of the case. So the answer is yes. Millie has Millie has answered for question number 7, not for 8. Amit and Kirti, I know the exact logic which you have applied to answer this question, because you know that the latest one is Joseph Shine. So the answer is going to be, either A or B, right? Clear? So there are no chances that C or D can be the answer. Chaliye, now let me tell you students, all these 4 judgments are landmark judgments on the concept of adultery. Okay, the latest one, I hope everyone remember, Joseph Shine versus Union of India 2018. Now the question is, which one was the first? Now let me tell you one interesting fact. In all these 3 cases, Yusuf, Revati and Kalyani, all these 3 cases, the question was same before the Honorable Supreme Court, that whether adultery is constitutional or unconstitutional. And in all these 3 cases, before Joseph Shine, if you go before Joseph Shine, these 3 were basically the landmark judgments on adultery. And in all these 3 cases, the Honorable Supreme Court held that yes, Section 497 is constitutional. But finally, under Joseph Shine versus Union of India, it held it's unconstitutional. Now coming to the answer, B is the correct answer. The very first time when this question was raised was in Yusuf Abdul Aziz versus State of Bombay. Okay. After that, V Revati, then it was W Kalyani, and finally then Joseph Shine. So B is the correct answer. Okay. Moving to the next one. Millie, correct answer for question number 8. Top 3 students to answer correctly: Kirti, Akhilesh, and Amit. Everyone's answer is correct. And that is basically A. Navtesh Singh Johar versus Union of India is not a landmark judgment on 498A. It's on 377. I hope everyone is aware with the facts of K.N. Mehra versus State of Rajasthan. It's there are interesting facts in this case. So I hope you know about that. Okay. चलिए जी. Next one. One more thing. It's again a landmark judgment. This Majumdar is a landmark judgment on 124A. A, with intent to murder, administered a fatal dose of poison to Z, and then while Z was still alive, a stranger B, without A's knowledge, attacked Z and him dead and make him dead. Now, what offense has been committed by whom? Okay. I hope you are able to read the comments easily. All the comments. Okay, I've got the answer from Amit and Kirti. What about others? Okay, Millie has answered B. Okay, fine. So students, here the correct answer is C. A would be guilty of an attempt to murder, okay, and B would be guilty of murder, okay. Now coming to the reason why the answer is not B, okay. Millie, listen carefully. A, with the intent to murder, administered a fatal dose of poison, okay, to Z, and then while Z was still alive. See, this is the reason. If after the poison also, if Mr. Z was still alive, it means it cannot be culpable homicide. If you can recall, Millie, as per to section 299, one of the most important essential is cause death. So that if the death has not caused by Mr. A, then it cannot be case of culpable homicide. And if there cannot be a case of culpable homicide, in no case it can lead to the offense of murder. So that is why we will give punishment of A for the attempt to murder. And what about B? Now, a stranger B, without A's knowledge, attacked Z, which means there is no concept of section 34 here. There is no concept of joint liability because A, without A's knowledge. So if B attacked without A's knowledge, so and make him dead, then in that case it's completely case of murder. So B would be guilty of murder. I hope everyone is convinced with answer number C. Done? Chaliye ji. Next one. A police officer tortures Z in order to induce Z to confess that he committed a crime. A is guilty of an offense under. So do we have any specific section in relation to this situation that a police officer cannot torture someone for the confession? We all know the basic concept of confession is that it must be voluntarily. Top 3 students to answer correctly: Amit, Akhilesh and Kirti. And yes, it's correct answer. That is D, section 330. It's the correct answer. And what is going to be the evidentiary value of that confession? Anyone? What is the evidentiary value of that confession? that has been given to the police officer after all that torture? And the answer is 0. Can you recall any section number? Not relevant. Section number 25 of Indian Evidence Act. Wonderful. Match the following. Okay, let me tell you one this observation as well. When it comes to UP Judicial Services, I think matches when it comes to the section numbers or landmark judgments. Most of the questions are going to be from the famous important section numbers and landmark judgments, and match the following. So this is one of the favorite topic of the examiner. So when you are spending time with the Bayer Act, just keep that note in your mind. Okay, top 3 students to answer correctly. First one, Kirti, followed by Akhilesh, Amit. Correct answer. Millie, please do correct your answer. Okay, let me help you out here. See, the first one is delivery of property. So when it comes to delivery of property, it is basically your extortion. Okay. When it comes to taking of property, it is basically your theft. When it comes to entrustment of property, it is criminal breach of trust. And when it comes to criminal misappropriation of property, it is convertibility of property got innocently to one's own use. Okay, ji. Next one. It's okay, Millie, you don't need to be sorry. This question is from CPC. Assertion: a civil court has jurisdiction to try all suits of civil nature. Reason: the cognizance of a civil suit should be expressly barred. मोहम्मद सर क्लियर नहीं दिख रहा है. मोहम्मद, आई guess कि there is no issue from my end. You please do a refresh. Okay. Because in case if there is any issue from my end, no one can read the question. Okay. Okay, Nabia also. Students, please confirm. Akhilesh, Amit, Kirti, please do confirm. Are you able to read the question or not? I hope my internet is still working. Okay, Nabia and Mohammed, uh, I guess the issue is in your internet. Okay, so please do a refresh. Now, coming to the answer of this question. See, when it comes to statement 1, a civil court has jurisdiction to try all suits of civil nature. This is completely correct. But when it comes to reason, the cognizance of a civil suit should be expressly barred. No, that is false. So the correct answer is C, is the correct answer. Disclosure of identity of a victim of a rape is punishable under. नाबिया एंड मोहम्मद, यस, आप प्लीज अपना रेजोल्यूशन थोड़ा सा बढ़ा लीजिए सेटिंग्स में जाकर. आई होप दैट वुड हेल्प. Top 3 students to answer correctly: Amit, Akhilesh, and Kirti. Everyone's answer is correct. That is D, section 228A. Okay, now can you please tell me 228 also deals with identification of victim of murder as well? Answer in the comments. Section 228A applies to the disclosure of identity of a victim of murder as well, or only for the victim of rape? Amit, no. Kirti, no. Completely correct answer, students. It deals with only identity of a victim of rape. Okay, it includes sexual offenses as well, other sexual offenses like sexual harassment and so on. Okay, only for the victim of rape. That's the correct answer. That's the correct answer. क्या बात है, बहुत बढ़िया. Moving to the next. No right of private defense of property is available against the offense of. Correct, Kirti. 376 से लेके 376E तक. In short, all the punishments that included the concept of rape. Starting from Akhilesh, Kirti, Nabia, and Amit. Millie. Everyone's answer is correct. That is a criminal breach of trust. Now let's see who can tell me why there is no right of private defense of property available in case of criminal breach of trust. What is the reasoning? I'm interested in knowing the reasoning for that answer. Why no right of private defense of property when it comes to criminal breach of trust? Let's see who can answer that. Try to be as specific as you can in your answer. What about others? I have already read the answer given by Amit and Akhilesh. What about others? Kirti +1, Amit. That's good. Chaliye, let me answer. Akhilesh, please do correct your answer. Amit's answer is correct. That is, the reason is, see, first you can give me the reasoning of section 103 as well here. Okay, so section 103 includes theft, robbery, and criminal trespass, but not criminal breach of trust. The reason is very simple. Whosoever has committed criminal breach of trust, the party is aware about that person. Okay, and in that case, the person has all the time to go for the authorities. Okay, and not to take law in his hands. The bail is rule, jail is exception. This rule is laid down by the Supreme Court in which landmark judgment? This is one of the favorite question for mains examination as well. Like, explain the concept of bail, and jail is in exceptional circumstances when it may do injustice. Like, for example, when the accused may do criminal intimidation against the witnesses, or if he may disappear the evidences. In that case, in the exceptional circumstances, we go for the jail. Bail is the general rule. Akhilesh, Kirti, Millie, everyone's answer is correct. That is C. Motiram versus State of MP. It's a correct answer. It's okay, Kirti. It's okay. Happy birthday to your brother as well. So just enjoy the party. Okay, ji. We will continue as the show must go on. When a search is required to be conducted outside India, a court may require under section 166A of CRPC the procedure to issue a what? Procedure to issue a what? Search warrant, letter of request, letter of requisition, written order. Amit and Akhilesh, correct answer. That is B, letter of request. Students, when it comes to police, and if they wants to enter into even in another state, there is a procedure prescribed. So when we are talking about out of the country, obviously you cannot enter in other country without their permission. So for that you need to issue a letter of request. Okay, so B is the correct answer. So beyond the limits of India, it's all about 166A. Which provision of CRPC resembles with the concept of habeas corpus writ? Produce the body. Top 3 students to answer correctly: Amit, Akhilesh, Nabya, and Millie. Everyone's answer is correct, and that is section 97. Section 97 basically reminds you the concept of habeas corpus. Law is a reason free from all passion. The statement is of the following. So this question is basically from your jurisprudence. Law is a reason free from all passion. Students, yesterday also I pointed out that you need to work on the concept of jurisprudence. Okay. And the correct answer is D, Aristotle. Okay. And usually you are going to get some factual questions only when it comes to jurisprudence. I know it's hard to remember the statements, but this is what it is. Okay. You don't have any other option. If A writes, who is unable to speak, gives his evidence in writing, in the open court, evidence so given shall be deemed to be. Documentary evidence, oral evidence, primary evidence, secondary evidence. Top 3 students to answer correctly: Akhilesh, followed by Nabia and Pooja. Amit, correct answer. Millie and Mohammed, please do correct yourself. The correct answer is oral evidence. Okay, so let me give you an example. If there is a person who, because of the physical inabilities, if that person cannot speak, okay, then in that situation, if that person is writing, giving his evidence in written form, so that is not going to be treated as documentary evidence. That will be treated as oral evidence. Can anyone recall any specific section number for that? Any specific section? Yes, Amit, correct answer, because section 119 of Indian Evidence Act confirms that. Now my last question, if you can answer that. Why it is considered oral evidence and why not documentary evidence? Because at the end of the day, it is something which is written on the paper. So why not documentary evidence? Why not documentary evidence? Why oral evidence? Can anyone tell me the reasoning? Section 119 confirms this concept, but under section 119, there is no reasoning written there. So most of the times you have to read between the lines. So which one is the concept? What is the hidden concept here? Why oral evidence? Anyone? Should I answer? Last 20 seconds. Okay, now listen carefully, students. If we are going to treat that as a documentary evidence, then the person who is not able to speak can never give oral evidence. Reason number one. if you are saying, sir, we are going to treat that evidence as a documentary evidence, it means that particular person who is not able to speak can never give oral evidence because of his physical inabilities. Now coming to the reason number 2, as a student of law, we all do understand that documentary evidence has always a greater impact. Okay, be it section 91 of your Indian Evidence Act, we always prefer documentary evidence. But what kind of evidence that person wants to give, Mr. A? Documentary or oral? The answer is oral. But why he cannot give oral evidence? Because he is not, he's there because of the physical incapabilities. And because of only physical inabilities, he is writing that all things. So we will still treat that evidence as an oral evidence. I hope now it's clear. Done? Sure. Next one. The case of Pakala Narayan Swamy versus Emperor relates to. First one to answer correctly, Pooja, followed by Amit and Akhilesh. I guess a landmark judgment, an easy one. And the answer is dying declaration is the correct answer, students. In which of the following accomplice is declared a competent witness? In which of the following accomplice is declared a competent witness? Okay, except Zara, everyone has answered D. That is 133. Okay. So, Zara, please listen carefully. If you are answering section 114, first of all, section 114 is just a presumption. And the reason you got confused is because of the illustration, the relationship of the illustration of section 114 with section 133. Okay, so the correct answer here is 133 because section 133 declared accomplice as a competent witness. Okay, so D is the correct answer. Justice is the first virtue of social institutions, is the observation of whom? This is again coming back from the jurisprudence. I know 99.9% students now, it's going to be a fluke. Yeah, illustration F of section 114, read with 133, completes the concept. Okay, I guess there is a spelling mistake. This is Mahatma Gandhi. Okay, it's a matlab like there's an error. Okay, it's Mahatma Gandhi. Okay, ji, Mahatma Gandhi ji. And students, the correct answer is D. John Rawls is the correct answer. Okay. The Supreme Court is the guardian of the rule of law. This observation has been made by the Supreme Court in. Rule of law, Article 14 of the Constitution of India, and the Supreme Court is the guardian. And the correct answer here is Bijoy Kumar Mohanty versus Jadoo. So D is the correct answer. Which one of the following is not included in Article 21 of the Constitution of India? Yes, Millie, it's a landmark judgment. Top three students to answer correctly: Amit, followed by Millie and Zara. And everyone's answer is correct, including Akhilesh. That is A. Students, Article 21 is your right to life, and right to life does not include right to die. Okay, ji? Section 309, it's still an offense. Okay, so attempt to suicide is an offense. Directive principles of state policy are relevant for determining the reasonableness of restrictions under Article 19, Clause 2. Directive principles of state policy have been declared superior to the fundamental rights. Both Ankit and Swalia, both correct. Akhilesh as well. These all three are the landmark judgments. Aruna Shaunbag, P. Ratnam, and Gyan Kaur. Students, always do remember, directive principle of state policy are not superior than the fundamental rights. DPSP are not superior than fundamental rights, which means A is true but R is false. So C is the correct answer. Okay. There is a spelling mistake. This is Dudnath Pandey, not dude. This is Dudh, D-U-D-H. Okay. The case of Dudnath Pandey versus state of UP is related to which one? Akhilesh, correct answer. That is plea of alibi. C is the correct answer. Dudnath Pandey is a landmark judgment, by the way. Okay. If you are not aware with the facts, please go through with that. It's a landmark judgment. This will help you in the mains examination as well. Dasti summons for service on the defendant can be given to the plaintiff under Top 3 students to answer correctly: Nabia, Mohammed, and Amit. Everyone's answer is correct. That is A. Order 5, Rule 9A. The maxim nemo debet bis vexari pro idem causa finds place in which of the following section of CRPC? Akhilesh, correct answer. That is section number 300. And here comes the last question. Which of the following is not correctly matched? Nabia, please do correct yourself. Swalia, Akhilesh, correct answer. D is the correct answer. Okay. Chaliye ji. So this is the link of my profile, my Telegram channel, and this is my code Khatri10. Student important information to share with you all. There is a price drop alert for judicial aspirants, and the offer starts from November 25th. This will be applicable on both Plus and Iconic courses for 24 months and 12 months subscription. Okay. Now the another thing is there is judiciary test series for December, and there is everything for all of us, for special students as well, for Plus students as well, and for Iconic as well. And this is the revived test series, so this is going to help you a lot in your upcoming examinations. Okay. This is the batch which is recently going to be started in Unacademy from November 28th, Sarthi 4.0. This is Rajasthan State Judiciary batch, which is going to be start from November 18th. This is the result from Unacademy of Rajasthan Judicial Services examination. These are all the features of Unacademy Iconic. This is the YouTube and the Telegram channel of Unacademy, and that's it from my end. Amit, it's 357A. Okay. Chaliye, you all are welcome. So see you in my next class. Till then, yes, it's time to say peace.